Thank you very much, Louise. So yeah, just to briefly reintroduce, I'm Tom Furnival. I've worked at Mewburn Ellis for almost 8 years now. I'm a chartered European and UK patent attorney, and before I was doing this, I did a master's in physics at the University of Exeter, working sort of solid state research and theory. And so my practice is electronics engineering, high-tech physics, all that kind of stuff. As a brief intro to Mewburn Ellis, I'll try and keep this bit nice and short. We're a business founded with a passion for science and technology. We're almost 300 members of staff now, and over 100 of them are scientists, engineers. We've got legal experts, trademarks, business management experts. We work for companies across the whole spectrum of technologies and sizes. So, my practice is electronics engineering and physics and all the rest of it. We've got colleagues working in biotech, chemistry, polymers, batteries, medical devices, you name it. We work on it. We've got someone who's a specialist in it, more than likely. And in terms of size, we work from everyone from startups to big multinationals, universities. And it's worth noting, startups and SMEs, small, medium enterprise businesses, account for over 40% of our client base. We do a lot of work with SMEs and startups. And that means that we really get to grips and familiar with the challenges that researchers and innovators see when they are setting up their businesses, looking for seed funding, trying to protect their corner in the market. And a final nice plug from the legal reviewers: we're top tier and recommended by various reviewing bodies. So, quick summary of the aims of the talk. Hopefully it's to provide you with an overview of intellectual property basics, what they are, what you can do with them, how you might get them, etc. Just some practical guidance on how to factor IP into what you do as a business, and how you can use it to magnify what your business is doing out in the marketplace. And then at the end, we've got some examples so we can try and put some of that guidance into practice. Why now to give this kind of talk? Well, as Louise said, we had this presentation earlier this year, and it garnered a lot of interest. But also, Mewburn Ellis have done some research together with YouGov, where we surveyed over 400 SMEs in the UK. And from that research, we put together a special report, which you can find on our website, or I can share a link afterwards by email. You can just search Mewburn SME report. And one of the, I think, really interesting findings from that, we asked companies what following statement about IP best applies to your business. And about 20% said we're doing stuff with IP, and we've got a major reason for doing so, and we protect all our IP. 20% said we protect some of our IP, but most interesting for me is that 20% of businesses surveyed thought that their business did not produce any intellectual property. And I think hopefully this talk will aim to mitigate that and illustrate that really almost everyone working in commerce is going to be generating some kind of IP that's worth protecting. So, as an introduction to IP, what is it? Well, WIPO, which is the World Intellectual Property Office, it's based in Geneva, it's part of the WTO organization. They define intellectual property as creations of the mind, inventions, literary, artistic works, symbols, names, images, and designs used in commerce. And that's the kind of intellectual property that's people have created. But practically speaking, IP rights, so intellectual property rights, give you ability in law to stop someone else from using your ideas without your permission. And really crucially, it's not a right to use. So if you get a patent for an invention, that doesn't give you the right to practice that invention. It just gives you the right to stop other people from practicing that invention. So now I'm going to talk briefly about what kinds of IP exist. And I've already mentioned, patent applications or patents. These are IP rights for technical inventions, so new products, a new antenna in a smartphone, or a new kind of drug that treats a disease. But you can also get patents for methods, so a new method of applying a film on a surface that's really better than what people have been doing before. Or you can get patents for new uses of existing things. And this is normally in the medical sector. So someone has found that existing drug A also treats a different disease, and that people didn't think it could, and so you could get a patent for that medicine for use of treating that disease. You also get trademarks, another one I'm sure people are very familiar with, which is protecting your branding. So not only is this for the logo of your business, we've got our nice Mewburn Ellis roundels in the top right corner, or the name Mewburn Ellis, but if you've got sufficient clout, it can be for colours. So EasyJet, for example, have trademarks on their EasyJet orange. Cadbury's had a long legal dispute about Cadbury's purple. So it's broader than what people may initially think. We've also got design rights, which is a slightly more niche one. So whereas patents protected a technical innovation, so a new interesting invention that does something technically useful in the world, a design right protects the way a product looks aesthetically in a way that's broader than copyright. So a few years ago, there was in the news, people were talking about Apple having a patent on a rounded rectangle for use in iPads. And that arose because in the US, design registrations or design rights are called design patents. And then technical patents are called utility patents in the States. But Apple had registered some designs for the way their iPads looked, and the judge said, well, that looks too, Samsung's products, who were defending in this instance, the judge said that your Samsung tablets look too much like Apple tablets, and so you're infringing these design rights. You also have copyrights, which I'm sure lots of people are familiar with. Those are creative works, so literature, books, music, artistic works. Also algorithms, so computer software as written benefits from copyright, and you can often pair those quite nicely with, the software itself has copyright based on someone having written that code, but also the underlying technical principle of that software might be patentable. So you can have a nice synergy between those two. There's also trade secrets and confidential information. I'll talk about these in a bit more detail later on, but trade secrets is commercially valuable secret business knowledge. So that could be your secret sauce. When you set up this product for your customer, you set it up in a particular way that you haven't told anyone else, and it works really well as a result. Or it can be client information lists, your pricing lists that are confidential within the business, or supply chain information. All this kind of stuff falls within trade secrets and confidential information. And then there's some others as well, plant rights, design, database protection rights, things like that, which I won't talk about those for now. But what's worth noting is, multiple IP rights can clearly exist in or for one product. So taking Tesla as an example, they've got a lot of patents and patent applications. They've got patents for the charging technology, for the software that's running in their vehicles, for the battery technology, the battery chemistry. All parts of their vehicle can be subjected to patents as they innovate in there. But not only that, they've got over 1,000 trademarks. So they've got the logos for the Tesla motor, they've got the model numbers, so Model Y, Model X as trademarks. They may even be trying. Land Rover for a long time had trademarks on the look of the Defender vehicle. So Tesla could be aiming for that kind of stuff as well. And they've got a lot of design registrations. So this example is quite nice, where Tesla have decided that the way in which the indicator stalks look in their Tesla is sufficiently new and different that they want to protect that and stop people from making indicator stalks that look too much like Tesla's indicator stalks. Moving on to kind of general points about IP, it's worth noting and remembering that IP rights are territorial. So the specifics of them vary country by country because they arise from national law. In almost all cases. So in the UK, we have the UK Patents Act of 1977, got the Copyright and Design and Patents Act, giving rise to copyright and designs. And the specific rules of them will vary country by country, but there are a lot of international treaties that define either minimum standards. So the Berne Convention is a big international treaty that talks about minimum terms for copyright and what works should benefit from copyright. There's also national and regional systems for acquiring intellectual property rights. So at the moment, you can apply for a UK trademark, and separately, you can apply for an EU trademark that covers the entire European Union. But also for patents, you can apply for still a European patent application that will cover the UK because it's a separate system to the EU. Some IP rights arise automatically. So as soon as the intellectual property has been created, those are copyright, unregistered design rights, trade secrets, but they're usually quite limited in scope. So they only typically protect against copying directly by a third party. Whereas other, usually stronger intellectual property rights have to be applied for, so patents for registered designs, trademarks, because they protect not only against copying, but also independent creation. But part of that is you've got to better define the scope of what it is you're looking to protect. So a patent application or a patent will try and define the invention in broad terms to cover not only what you've invented, but other things that rely on the same principle, which is why they have to be registered for, because they've got to be, in most cases, examined, checked whether they're valid or not before the relevant government will grant them as a right that can be enforced against third parties. So in terms of terms, so how long these intellectual property rights last for unregistered designs, it's 15 years from when it was first recorded in physical form or on, in a CAD software or something, or 10 years from the first sale. Copyright depends on the work. So for some examples, literary, musical, dramatic and artistic works. It's life of the author plus 70 years, so quite a long term. But trade secrets, as long as it's kept secret, you know, there's no expiration on trade secrets. Whereas obtaining intellectual property rights through for the registered rights, patent applications, getting them to grant typically takes several years. You know, you can get it through faster if you need to. A lot of the relevant intellectual property offices have acceleration mechanisms that allow you to say, we really need this granted because we know someone's infringing it, or we need it to secure investment or something like that. And once registered, they often last up, you know, around 20 years from when you filed it. And there's provisions if you work in the medical or agricultural spheres to get an extension because of your market approval requirement, which stops you from selling the product up until you get clearance for it. So patents take a long time. Designs take relatively little time. To get a design registered, it's normally 1 to 2 months, and they last up to 25 years. And that's partially because designs are not examined in the same way as patents, certainly in the UK and Europe. They just look at formal requirements rather than comparing your design to all designs previously disclosed to mankind. And then trademark registration around 6 months, but they can last forever, you know, if you're using them. So a nice example is that the first ever trademark registered in the UK was for Bass beer with the red diamond, registered in 1860 something, still registered, still a valid trademark, still in use. But one of the requirements is you've got to be using it still. So you can't just register a trademark and then never sell anything under that branding or you're using that mark, because if you didn't, a third party could come along and say to the trademark office, well, look, they're not even using that. It's not very fair for them to have a monopoly on that right, is it? And then you're open to challenge. In terms of costs, design filing's quite cheap because of this lack of examination. To get a design on file, maybe £900, £1,000. Once it's granted, there are renewal fees for all of these registered rights. You have to pay fees to the relevant office every so often to keep them in force. Designs are renewed every 5 years. It's £300–400. Trademark, a bit more expensive and needs a bit more thought about what exactly you're trying to cover in terms of goods and services. But the filing costs for that around £1,300 in the UK ex VAT, and then renewal fees again every 5 years or so. Patents, these are the, you know, as the chart is showing, more expensive ones. To prepare a patent application from a disclosure of the invention or a discussion of the invention by the inventor, £3,000 to £10,000. You know, if it's a relatively simple mechanical widget type thing, it'll be on the cheaper end. If it's a very complicated, you know, it relies on cutting edge science, or it's in a particularly difficult legal area, so computer software or some biotech type inventions are in a difficult legal space, it can be far more expensive than that. And then once filed, they will be subject to examination by the relevant patent office. So that will mean that an examiner at the UK patent office will write to you and say, well, I've done some searching and I don't think your invention is new, or I don't think it's clever. And then we'll look at that, have a think, right, that they're wrong because of this, or they're right, so we need to change what we think the invention is. And you have several rounds of correspondence with the patent office. And each lot of that, you know, each round of examination has a certain cost with it. So normally we would say lifetime from filing to grant, £7,000 to £12,000. And then again with patents, renewal fees are paid. They're only paid once granted for UK patents, and they get progressively more expensive. So if you remember, patents last about 20 years. The renewal fees at the start are quite cheap, but as you get further along in the life of the patent, they get more and more expensive. With the theory being that it should be incentivizing you to think, do I really need this patent still, or would it be better to kind of at this point open source it and allow third parties to use that invention? So I'm going to do a bit of a focus on patents now. What's required for an invention to be successfully patented, and one of the first requirements is that it's a suitable kind of invention. And that's defined in law, which is harmonized pretty much across the world. So for example, methods of doing business. You know, if you came to me and said, I've invented a better way of doing escrow so that people are at less risk when they're transferring assets, that's unlikely to be patentable because it's going to fall in one of these exclusions. The same with presentations of information. Computer software is a very difficult area. It's excluded per se or as such, as the law says, and then there you've got to have a long, hard think about whether you're on the right side of this line where, you know, computer software that solves a technical problem controls a factory better so that you're more efficiently producing products or something like that probably would be good. But computer software for computer software's sake, so I've written an algorithm that calculates pi more accurately, is unlikely to be patentable by itself. The next key requirement for a patent is that your invention is novel, so it's got to be new. And that's novelty as compared to everything that is the prior art. Well, prior art is everything that's been disclosed to the public before the first filing of your invention. And that includes your own disclosures. So if you went down the pub the night before and told someone, oh, here's my invention, it's great, and they weren't under an obligation to keep it secret, then that's a disclosure to the public. And that could stop you from getting a patent granted to your invention. One of the next requirements is that your invention needs to have an inventive step. And this is really assessed as the opposite, as would it have been obvious to the skilled person to have arrived at something that's your invention. So, starting from what was known, would your invention have been obvious to someone working in this sector? But the skilled person, importantly, is someone with no inventive skills. It's not you, or it's not the inventors. The amount of times I've had inventors come in, oh, but this is really obvious, everyone would have thought of doing this. No, you thought of doing it because you're an inventor. And the test is whether this legal fiction, this skilled person, whether they would have thought of doing it. And that's, the novelty test is quite black and white, it's either novel or it's not. But the inventive step is really where we get into the nitty gritty of arguing, well, would it have been obvious to take that drug and add a particular functional group or something, or is that something that really you wouldn't, out of left field, you wouldn't have thought of doing that? And really importantly, it doesn't need to be groundbreaking inventions to satisfy the requirement of the inventive step. Most, if not, the vast majority of patents, granted patents, are for incremental improvements to existing products or types of product. And it also doesn't need to have a technical advantage for your invention to be considered to have an inventive step. One of the fourth requirement for patentability is that it needs to be capable of industrial application. And this one's almost never a big deal. It's there because the Patent Office, by edict, government direction, will not grant patents to perpetual motion machines and things like that. And the way in which they exclude those kind of inventions, in quotes, is by saying, well, no one could make this. It's not capable of industrial application. The final requirement for a patent is that you need to clearly and completely describe how to work the invention. This is the deal that you're striking with the government is, well, in exchange for you telling the world what your invention is and how they can use it, you will be granted a monopoly by the government to stop other people doing that for a set period of time. That's the deal you're striking. And if you don't describe it completely and sufficiently, then you're not upholding your end of the deal. And so, there's grounds there for them to say, well, I'm not going to give you a patent because we don't know how to work your invention. What's important to note here is that you don't need to necessarily explain why or how your invention works. So quite often it's the case that someone says, well, I've done this and I get this result, but I don't understand why or how. That's fine, as long as you can describe how someone could use it. You don't necessarily need to describe how it achieves the invention, the technical effect that you're getting from your invention. So, moving on to talking about how to get a patent application or a patent granted. We've got this timeline starting at T0. Now, actually, there's work before T0. T0 is filing your first application, but you would go to a patent attorney or whoever and say, I've invented something and I want to get a patent for it. And you'd have a discussion. You prepare a draft patent application, and then once that application is prepared, you file it at the Patent Office, and that establishes a line in the sand. It's called the priority date. That's the date from which you're going to be assessing novelty and inventive step. And really importantly, it means that anything that you disclose after that filing, that it's the same as your invention, shouldn't affect the novelty of your invention, because we're saying, okay, whilst you filed your application on the 1st of January and then you disclosed it at a conference on the 10th of January, that's okay, because at the time of filing, it was novel and it was inventive. The first filing then starts a 12-month clock running, which is called the priority period. And by 12 months, so taking our example, around the 1st of January next year, you needed to have filed any other applications that you want to benefit from that same earlier date. So, taking one example, you file at the UK Patent Office 1st of January, and then 12 months later, you file your European, your US, your Korean, your Japanese patent applications, and all of those claim priority back to the earliest application. That could be quite a powerful tool for going out and drumming up investment. You've developed your invention, your product, you get something on file, you've now got 12 months where you can go ahead, drum up some investment, get some interest in your product, check whether it's going to be a goer or not before you take the big expense of filing, a big filing program abroad. Once you've done that, you get another 6 months. So this is 18 months from your first filing. And at that point, your patent applications will publish, and pretty much they'll all publish around the same time. So it means at that point, all the content, technical content of your patent application becomes public, and people will know that you've applied for a patent application and what that invention is that you're seeking to protect. After that, you get examination, which is going to be done according to local laws. So your UK application is going to be examined by the UK Patent Office, your US application is going to be examined by your US Patent Office. And then, hopefully, eventually you start getting grants. So you've convinced the examiner that your invention is novel and inventive, and they'll say, okay, I'm going to grant you a patent for that now. Typically, given the backlog of the various patent offices, that's 30 months plus from your first filing. But as I said, there's mechanisms that you can use to accelerate it. After grant, I already mentioned you've got to pay renewal fees to keep them in force. That's just to make sure that people don't obtain these 20-year monopoly rights and then do nothing with them, and don't try and monetize them in some way. Crucially, it's only after grant that you can stop others from working your invention in the country where you've got that patent granted without your permission. Until it's been granted, you can put people on notice and say, well, look, I've got this patent application, I think it's going to grant. You need to have a long, hard think. But you can't start an action at the court because the right hasn't been granted at that point. It hasn't had the sign off from the Patent Office that they think it complies with all the requirements. And here, stop it, if someone is using your invention, that's called infringement. And infringement has some specific acts that need to be performed to be deemed infringement. And in the UK, that's making a product containing the invention, or making the invention, using the invention in a commercial sense, selling the product containing the invention, or offering to sell it as well. They don't have to actually be selling it and making money, or importing. And so that's the importing one's quite an important one, because a lot of companies won't want to invest significantly in a global portfolio. It's only tends to be the big pharmaceutical companies that will do a worldwide global filing program, and instead you're going to be looking at what markets you think are most important to you. And so you might think, well, okay, UK is my home market, US is going to be a big market for this product, China is probably where it's going to be made based on manufacturing base. But you don't necessarily need to go for a Chinese patent if you can stop people importing from China into the UK and the US. You'd be in a stronger position if you could stop someone in China from making it, but it's not necessary in this case. One thing you need to know is that after grant, your patent's open for post-grant invalidity proceedings. So just because the Patent Office has gone through and signed off on it and said, yeah, we think it's patentable, that doesn't mean it's never challengeable. A third party could go away, do some searching, come up with some new prior art documents that maybe the UK examiner didn't know about, and based on that say, well, I think actually based on this, you shouldn't have been granted that patent. And one of these often follows the other. So big company Nokia will assert a patent against Ericsson and say, we think you're infringing, and in reply they'll say, well, you shouldn't have been granted that anyway, here's an invalidity action. You can also, well, you should be monetizing your patents. Just having them by themselves, it can be quite nice on an asset sheet, and it can be some comfort during due diligence for investors that they know that someone's not just going to, you're not going to order 100,000 units from China and the next day someone else can order 200,000, pay half the price and undercut your position in the market. They want to know that their investment's going to be protected to an extent. But monetization can happen before or after grant. You can license a patent to someone before it's been granted. Obviously, that will affect maybe the value of the licensing fees. You say, well, I'm optimistic that this is going to get granted, so I think you should take a license now, or they might want to wait until it's been granted to see. You can also sell patent applications or patents at any stage of proceedings. So as soon as they've been filed, that provisional right exists and it can be transferred like any other asset. For licensing, it's nice to note that you could license a patent or application in its entirety or in part. So you could say, well, I'm going to let you do this particular version of my invention, and I'm going to license you for that. But the other versions of my invention, I'm going to hold on to those for myself, and I'm going to not license those. You can also license territorially. So you could say, well, I've got this European patent application that's going to grant. I'm not interested in the Baltic states, so I'm going to license those to local entities to go ahead and make the invention. But I'm going to keep the UK, Germany, and France for myself. Licensing is also a key tool for cross-licensing opportunities. So saying to someone, well, I want to implement what you're doing, but I think you might want to implement what I'm doing. So why don't we strike a deal where we can both use these inventions in a way to make us both some money and still keep other people off the turf. And another way of monetizing it is to use tax relief that's available for companies or individuals that own patents. And a key example in the UK is the UK's patent box, where you can get some, I'm not sure the exact number, but some percentage, integer percentage of your corporation tax back. And I've got a client that I work with who have told me now that, you know, they have made back through tax relief via patent box more than the fees that they have paid us to obtain those intellectual property rights for them. And so not only do they have the benefit of having those assets on the balance sheet and knowing that, you know, when they're tendering for work, they've got a competitive advantage that's protected that other people can't tender with. They've also, you know, they're making passive income from that, from this tax relief. So to move on from patents now to trade secrets, to start with, what is a trade secret? Well, it's information not generally known to the public, and it has to have commercial value because it's secret. You know, this example I gave earlier, it's got to be, it's you know, customer list or something like that, where you would be losing out financially because it became public. But one of the requirements, certainly in the UK law, is that the owner of that trade secret has to take reasonable steps to protect it. So one relatively famous example of a trade secret is WD-40, the oil, well, not quite oil, but water displacement spray. They never filed a patent application for that. They kept the formula as a trade secret. It's written down on a piece of paper and locked up in a safety deposit box somewhere in New York, apparently. And that for them, they feel like from that they can tick their box and say, we've taken reasonable steps to keep this secret. The actual reasonable steps, it is a test in law, and you need to check with a local attorney. But for example, you know, recycling paper versus shredding paper. You know, if you're just recycling it and it's got trade secrets on it, you may not be deemed to be reasonable steps to have been taken to protect that trade secret. It's beneficial because acquiring, using, or disclosing a trade secret without consent of the owner is unlawful, and you can be subject to, you know, at the point at which it's been disclosed, you're not going to be able to protect it any longer because it's now generally known to the public. But you can go after the person that disclosed it and say, well, you shouldn't have done that. I'm now losing out on profit or whatever, and you owe me some money in exchange for that, really. Or if you know that someone's using it, that they may have acquired it unlawfully, but it's not been disclosed, you could seek an injunction and say, well, I know you're using this and you've acquired it from an ex-employee and you really shouldn't be. You know, you could start an action to try and get them, you know, an injunction to stop them from being able to use it. Here, using it's sort of legalistic definition, producing something according to the trade secret, offering the trade secret, or offering a product using the trade secret, placing on the market, importing, exporting, storing, all that kind of stuff, using of products or services using that trade secret. Trade secrets are often considered complementary to patents. So, you know, do I go for a trade secret or do I go for a patent? You know, patents, finite term, 20 years, but broader protection. You know, I can stop other people independently coming up with this rather than people acquiring it unlawfully and using it. But you've got to consider, you know, if I'm going to rely on trade secrets, WD-40 presumably came across this problem. They are selling that product to people who are not, they have no contractual relationship with, who they can stop from taking it apart and putting it through a mass spec and working out exactly what's in WD-40. So, you know, more clearly for kind of mechanical inventions, if you're selling that and you're relying on the interior workings of that remaining a trade secret, how easy would it be for someone to reverse engineer that? And so is selling it to, you know, on the open market really going to stop you from relying on trade secrets? In which case you might need to think, well, if it's going to become public anyway, maybe I do want a patent application to be filed, because, you know, even if it doesn't get granted, at least it's going to buy me a window where people, you know, there'll be a keep off the lawn sign for a while. But the patents only have 20 years, whereas trade secrets could be forever. So if you're confident that you could keep it secret for long enough, maybe you want to benefit for longer than 20 years. For commercialization, it's easier to commercialize patents typically because they are public rights. You don't have to worry about whether you can share them, under just non-disclosure agreements or anything like that. It's clearer what they cover. It's clearer how they're implemented. Whereas trade secrets, it's much harder to pin it down and say, well, this is the trade secret I want to license to you. And in terms of infringement, it could be quite hard to know whether someone is infringing your trade secret if it's the secret source when you make your product, because just looking at someone else's product, you might not be able to know whether or not they've used your secret source when they made it, if it looks essentially the same as when if someone doesn't use it. Whereas for patents, you can get protection for the product in a much broader sense, and so it can be easier to prove infringement in those cases. People sometimes consider coexisting patents and trade secrets. So you've invented a process for applying a film on a surface, and you could file a patent application where you're quite broad about that, and you say, well, here's in general terms what my invention is and how I apply my film, but you keep some of the secret source back. You've disclosed it enough that someone could make something that you consider your invention, but you keep the exact temperature profile or the exact pressure profile secret. And that's a way in which you can try and run the two together. Clearly, that's quite difficult because you're going to have to disclose something similar to what your actual process is. And so whilst you can try and be broad about your temperature ranges, people are going to know that what you're doing is within that range somewhere. And so it might not take too long for someone to find out what's going on. Some other famous examples of trade secrets come across is the Coca-Cola recipe. That's a trade secret. The Google searching algorithms, that's never been publicly disclosed. They keep that very proprietary. And then kind of more generic examples, so specific methods, the secret sauce when you make, you apply your thin film or whatever, setups of machines, customer lists, supply chain knowledge, all this kind of stuff. So moving on to IP in practice, how can I apply all this knowledge in a way that's going to aid my business? Well, for starters, I'd underline an effective IP strategy can be crucial for commercial success. Depending on your sector, it might be utterly essential. If you're working in pharmaceuticals, you're going to need to get regulatory compliance or regulatory approval to sell your product. Part of that is going to be telling the relevant authority exactly what your drug is, exactly how you make it, and a best guess at how it works, but not necessarily, but data showing that it does work, in order to get that granted. And by this point, you'll have spent untold amounts of money getting to the point of getting your drug through approval. You want to be able to recoup some of that money. And maybe the money that you spent on developing the 7 other drugs that didn't work. But if you haven't got a patent in place, some third party can look at all your filings at the MHRA or the FDA and say, well, I'm just going to make that then. I don't have to recoup all these losses or all this money that I spent on R&D and research. So I'm going to sell it at $1 a pill rather than $100 a pill that you might be able to sell it for if you had a patent in place. So I'd encourage businesses to engage with IP right at the start, as soon as they can, and to monitor and update what their IP position is. It's best to build on a firm foundation, particularly because problems can't always be fixed. I mentioned earlier, one of the key requirements is novelty. If you've disclosed your invention, that can be it. In a lot of cases, you may not be able to get a patent granted to that now. So having this awareness earlier on is really key to make sure that you're on a firm foundation for protecting your position in the market. And depending on your exit strategy, what are you trying to do? You might want to get bought by someone, or you might want to float on the IPO or something, and people are going to want to do due diligence into your business. Well, how are you protecting your unique selling point, and how do I know that my investment's going to give me the returns that I'm looking for? I'd also note problems frequently only surface when they're the most troublesome. You're in the middle of due diligence for an IPO, and suddenly one of the auditor or whoever says, well, what's your IP position? What patents do you have on your products? Or you're a big clothing manufacturer. Well, you're really relying on this branding. What have you done to protect that? Oh, well, we haven't filed any trademark applications. Oh, well, I can see now that someone's cropped up in France and they're selling in a very similar brand to you. It's better to try and get on top of this stuff early. And part of that is just being IP interested. And by being at this talk, you clearly are IP interested. So probably I don't have to tell you that. But having an eye to how IP can help you with your business's ultimate commercial goal. So as I said, if you want to get acquired by someone, you want to be able to demonstrate that they need to acquire you in order to do what you're doing. Or if you want to seek external investment, that people are going to get their return on their investment. They want to invest in you. So part of that's thinking, do I have a protectable technology or a protectable brand? Am I doing things in my business that's solving? Am I solving technical problems to produce a product or to solve a technical problem for a customer or something like that? That's a good indication that maybe you should be thinking about patents. Or you think, right, I'm really pleased with my logo and I'm spending a lot of money on advertising and really getting myself out there and demonstrating that I'm a brand to be trusted. How annoyed would I be if someone started ripping this off in a way that's difficult for me to enforce? And so getting in there early, getting your trademark applications in, can put you in a much stronger position down the line. Worst case is you are making it big, you get the attention of someone, and then they're going to try and rip you off or something. Part of the technology point is, well, do I have a patent application? Am I comfortable that I'm protecting my invention? But also, is that patent application any good? Anyone can prepare a patent application at the patent office and say patent pending, but is it going to take a patent attorney 30 seconds to look at that patent application and go, it's never going to get granted? I'll advise this third party, you don't need to worry about that patent application because the chances of it getting granted are so slim that it's effectively not worth the paper it's written on. So just having patent applications, you need to make sure it's doing what you need it to do for your business. It's protecting what you're going to be doing. And part of protecting technology is getting an invention capture system in place. So do your engineers, do your scientists know when what they're doing should be protected? Are they IP savvy? Do they know about patent applications? Do they know that when they thought to add reagent A instead of reagent B, that's something that could be protectable if it's resulting in a better product or a better process? And do you know where to turn for IP advice? So Cambridge has a number of free clinics, IP clinics. I think it's organised by either the university or local libraries, where you can go and talk to IP professionals, or go online. There's lots of free resources. I plug Mewburn Ellis a bit because I often use the resources on our own website. We've got a huge amount of kind of information brochures about patenting the basics, trademarks the basics, infringement, all the rest of it. So moving on to your business's IP risks. One of them, I've already talked about it quite a lot. It's something I end almost all calls with inventors about. Please keep your invention confidential. You've got to remember that prior art, which can stop your invention being novel, includes any public disclosure, including your own business's disclosures. So an email to a supplier, I was talking, say to inventors, so have you disclosed this to anyone? No, I haven't disclosed it to anyone. Okay, and how are you getting your manufacturing sorted? Oh, well, I'm talking to a factory in China about getting some tooling done. Right, has that, have you been talking to them under an NDA? Do they know that they're not allowed to share the plans? Oh, possibly not. Right, well, that might be a disclosure that we need to worry about now. So it's really important that members of the business who have the opportunity for sending information externally know the importance of confidentiality. They have an extra step on their sending the email checklist of, have I put the right addresses in? Am I sending anything here that could be confidential in a way that I need to make sure that the other party knows is confidential, and they need to keep it confidential? And so part of that is asking about planned disclosures. So you're getting ready for tooling up, and product manager says, right, I want to go and I want to go to the factory and get them to sort out these bits and pieces. Right, are you planning to tell them about the fact that we've got iteration 2 of this product in the pipeline, and we're going to be adding this feature? Oh yeah, I was going to mention that to them. Right, well, you need to make sure that you discuss some non-disclosure agreements with them to keep it all confidential. It's worth noting, after disclosure in some countries, and it's not a huge list, if you've disclosed it, you have a relatively short window in which you can still file patent applications, and they won't suffer due to your earlier disclosures. So the US, Japan, Australia, all the kind of trans-Pacific countries, that agreement, all have grace periods in, and they're normally about 12 months. But the specifics are country specific, and it can be quite difficult to, you disclose it, which causes someone else to disclose something that's similar to it. So ideally, don't rely on disclosure periods. Grace periods is our normal advice. Touching on what we already had to talk about ownership and inventorship issues. Inventorship determines who owns the invention. So in the UK, typically an employer will automatically own any inventions owned by, generated by employees of that business. You know, if I employ a research scientist, it's reasonable for me to expect that any inventions they generate will belong to the business. But it's less clear cut in other instances. So you've got a contract worker who's doing some contract research for you. Well, who owns that invention when they come up with it? Well, you've got an intern or a PhD student doing some work with you. Well, who's going to own the stuff that they develop? And it's important because if you get it wrong, the ultimate patent that you try and get granted can be open to challenge. Say, well, you never owned that invention. You know, at least part of it was owned by a PhD student at the university. And so it's worth thinking about early doors. Do I need to get an agreement in place with the university or the contractor to say whatever you come up with is going to be mine, or we're going to discuss it and work out a deal if anything comes up? So moving on to third-party IP, the main consideration for third parties is whether you have freedom to operate or not. Does a third party operating in your sector or you know, just operating in general have intellectual property that could stop you from doing what you want to do? You know, do they have a patent for the method of making the product that we want to make, or do they have a trademark that's slightly too similar, or maybe they're trading in a goods and services which are a little bit too close to what we're looking to trade in, and that those can present barriers to your business's commercial activity. And it's better to find out about that early than late. You know, the amount of times we have people come in and say, well, I'm about to launch my new brand. I bought the t-shirts, I've got the website, you know, I spent umpteen thousands on someone designing a logo, and they say, oh, and then I thought maybe I should do some trademark clearance searching. We come back, well, someone's doing exactly, you know, someone is working in this space or a very similar space with a very similar logo. You know, it saves a lot of heartache if you get in early and do your due diligence before, you know, investing significant sums. But third-party IP can also be quite useful for providing an insight into what people are thinking of doing in that space. You know, a lot of people file patent applications speculatively. So, well, we're probably gonna move into this space at some point, and so we want to get some groundwork IP in place. We want to, you know, we'll invent some stuff quite well. We have invented some stuff in this area, and we're going to start filing on it. And so, looking into where your competitors are thinking of moving, you can get some insight based on what patent applications are being published for them. And so, as I said already, I really encourage early searching and monitoring early in a project. And so for patents, you can search on Google. Google have a special patent search engine, or SPASnet. The A is at is an A. That's the European Patent Office's search tool, very powerful, used by all the patent offices pretty much. Trademarks, you can search on TMView, which is the European Union's searching engine, and designs, you can search on DesignView, which is again the European Union's searching tool. You could do it yourself, or you can commission a search. There are a lot of specialist firms out there. Most patent attorney firms won't do searching themselves because it requires quite a specific skill set to do it effectively and cost efficiently. And so, you know, you could go to a patent attorney firm or an intellectual property firm and say, I want to do some searching in this area. Who do you recommend? Or can you help me to make sure that the search that they do is going to be useful? You're not just, you know, money for old rope, getting a search result back and going, well, I don't know what this means, or they've missed the point, or something like that, or it doesn't answer the business question that I've posed to them. And for problematic IP that comes up from this searching, there's quite a lot of things you can consider doing. You know, cross-licensing opportunities, like I said, saying, well, we want to do what you're doing, and maybe you want to do what we're doing. So why don't we set up a cross-license agreement? Or you can challenge that IP. You know, if it's an application still before the patent office, you can file what's called third-party observations, where you say to the examiner, you know, you may think this is allowable, but I don't, because look at this prior art that I found, and they can consider it and decide whether or not to grant it based on those observations. Or you can do formal opposition proceedings or court proceedings. So I mentioned this European Patent Office system. Once a European patent gets granted, there's a 9-month window where third parties can say, sorry, Patent Office, you got it wrong, this shouldn't have been granted for reasons. And that kicks off a big formal proceeding where the result will be maintenance of the patent as granted, or refusal, or somewhere in between, some limitation. Or you can consider workarounds. You know, is their patent tied to this kind of implementation, or do they need to use this kind of sensor or this reagent? And if we use a different one, can we try and work around it? That's a very difficult question to answer, and it's where we spend a lot of time advising clients about whether or not they're far enough away from what the third party has patented. So to take some examples of where you might see third parties patents, you could have a broad blocking patent. So, drug company A has said, right, class of compounds, big chemical space, and I'm protecting all of that. And what you want to do is right there in the middle, and it's nested. Well, some questions you could ask yourself that might help you is, well, does it cover countries of interest? Okay, they've got a US patent, but I'm not bothered by the US market. I'm only interested in the UK market. And if they haven't got a UK patent, then that might be all right. You can work their invention or something that falls within the scope of their patent and not be too worried. Or can we wait it out? Patents typically last 20 years. If this application's old, it's 18, 19 years old, is it going to expire soon? Can we just, we can get the groundwork in, but then wait until, this is a big deal in the pharmaceutical sector where generic companies will be like a hawk watching the expiration date of AstraZeneca's new cancer drug or whatever, waiting for it to expire so they can jump in and start selling generics. Or the cross-licensing opportunity, which I talked about a lot now. Or is it valid? Can I do some searching? I can convince myself that this isn't valid. And then you've got two options. For a lot of companies, we prepare invalidity kits, if you like, where they don't go to the point of filing the challenge at the court and saying this is invalid, but they have their arguments in their back pocket. They've got their evidence and their prior art. And if the third party approaches them and says, we think you're infringing, then the reply is instantaneously, well, you may think that, but we think it's invalid. Look at what we're going to do, the arguments we're going to make if you try and pursue this. Another kind of example is in the chemical space normally, but it can occur elsewhere, is overlapping patent applications. So, the patent by the third party is for a lubricant where they've got a particular compound at a range of molecular weights, and we've come up with our own lubricant, and it's got the same compound but a different range of molecular weights that kind of overlap slightly. And so there's a risk now that if we worked in this overlapping area, we might be considered to infringe. So clearly you can try and move away from that non-overlapping area to make sure that you keep yourself clear, but you could challenge validity of just that overlapping region. Well, it would have been obvious to work at the end of their range or something to try and punch a hole for you to go ahead and work the invention, or again, cross-licensing. So having talked at you all for a long time, I've got some example scenarios. So scenario A, you're a small company in the process of setting up a new business. You've got a prototype medical device made of a material which is known but not used in the medical device field. And you've shared a prototype of this with a big manufacturer so you can get it scaled up and sold out. And you're working on a manufacturing deal with them. You also aim to make a sustainable version of the material, and you find that the sustainable version is actually better suited for the medical device application than the original. What kind of things do we think we should be considering for this?
We have no responses. Come on, guys. Put them in the chat, or just unmute yourselves and answer.
I say
guess. Here we go.
Yeah, from H. Patent application to cover both materials. Excellent. What do you need to be worried about possibly for your patent application? Third line. You shared that prototype with a big manufacturer. Yeah. Was that sharing under an NDA? Hopefully. Maybe not. If it wasn't, you might be worried. Yeah, NDA. The sustainable version, you might need to think about, well, when we've now been working with a third party on this product, did they have any input into that sustainable version? Retrospective NDAs are very complicated and very rarely work. But the test in the UK is, would the parties have known or be expected to know at the time that the information was confidential and should have been treated in confidence? So a retrospective NDA, certainly in the UK, is not really a concept that flies. Either it was a disclosure which was made in confidence, or it wasn't. You can't go back and say, well, yes, of course, when I said that, I meant to say that it was confidential. The point I was making on the sustainable version is, when you start entering collaborations with people, you've got to have an eye to, well, what do we own and what might they own? did you have a brainstorming session with the big manufacturer where they said, well, you could also think about using that kind of material, or we're thinking about moving into this kind of material space, and maybe that was a prompt for you to think about your sustainable version. We've got 10 minutes left. I've got one more scenario and then some questions, so maybe no one wants to chip in for this one. I'll move on to scenario B. Right. So scenario B, a company approaches you about a new design for a window design for an aircraft. Concept arose from collaboration with a university and was designed by a master's student. You've been asked to integrate this window into a composite fuselage and test how it performs against industry standards. The company's provided you with a scale model, a draft of the master's student's thesis, and some drawings prepared by an undergraduate student at the university. What kind of things do we think we should be considering? Yeah, so H is all the participation. Agreement on ownership or sharing thereof with the university and student. Yeah, who's going to own the design for the aircraft, for the window? Who's going to own the know-how maybe in integrating it into the fuselage? Having all this kind of stuff in place, pretty key, pretty early on. Give it another 15 seconds in case anyone wants to chip in anything else.
H is doing a good job.
Okay.
Is there another prior art thing because of the thesis?
Well, yeah. So the thesis could be, a disclosure if the PhD, if the master student hasn't been, if the master student hasn't been careful with it. PhD theses often are cited as prior art, and so quite often will be embargoed by universities if there's a kind of third-party sponsor or industry sponsor saying, well, okay, we'll embargo the publication of that PhD for 2 years so you can work out your IP position. Yeah, you could be looking for a patent application for the process of integration when you work it out, and then you've got to remember that a company has approached you and asked about it, and asked you to do this research. So maybe even if you do come up with a patent application, you might need to think about whether who's going to own that. Probably if it's research by contract, it ought to be owned by the company that's paying you to do it. Trademark the design of the window. So trademarking 3D products is really tough because the balance, so design the pattern of the window, easy enough, you just send a picture. But trademarking designs is an interesting one because people do it. There was, for a long time, KitKat had a trademark to the shape of KitKat bars, and that got thrown out recently after a very long, protracted legal battle. Rolls-Royce have a trademark, Rolls-Royce Automotive have a trademark for the Spirit of Ecstasy, the model on the front of their cars. And it's a real balance that has to be made from a public policy standpoint, because trademarks are forever, whereas patents are only for 20 years. So there was an example a few years ago. Philips sell razors, electric shavers, with 3 shaving heads in a triangular pattern. And they've been selling those for a long time, and they are pretty unique to Philips. And they tried to get a trademark for it, a registered trademark to stop other people selling electric shavers with 3 shaving heads in a triangular pattern. And the court said, no, there's too much of a risk there, that has a technical benefit, which you would be stopping other people from using forever by granting a trademark on this. So yeah, physical trademarks, interesting, quite difficult. Lego, for example, have been trying for ages to get the Lego bricks trademark, but again, the courts aren't keen. Well, I think we've got a few minutes left, actually, so I'll move on to any questions